we're going to have somewhat of a high-level discussion on U.S. and some international sanctions laws, focusing really on, not only how they apply in a payments environment, but I really like to give you as much context as possible, at least for the U.S. law, so that you understand how this works. Sanctions laws are amongst the most commonly misunderstood that I deal with. They are, if you focus on them simply from a superficial standpoint and don't dig into the details, they can appear to be much different, much broader really, than they are in reality. And the fact is that OFAC can sanction all sorts of people for all sorts of different things, and depending on the details, those sanctions can have different practical rules in place. So we really need to dig into the details here, and so what I'm going to try to do again is give you that high-level understanding of how these things work, and I'm citing to regulations and I'm citing to different guidances that OFAC and some other agencies have published dealing with this sort of thing. So, to the extent that I don't get into the detail that you'd like, you can go back and you can look at those things yourself, and if you want to, you can download my contact card through that QR code and reach out to me that way.
Andrew, I just want to say one thing. I am disappointed that we're not full, because this is one of the hottest topics for federal regulators, given our work with, and concerns with China, with Ukraine, with Russia. I mean, they are checking everything very, very carefully, and they're looking for those programs. So this is really key to understanding this.
Yeah. So this year, for my own practice, sanctions laws have gone through the roof, and I've spent dramatically more time this year dealing with them than I have in years past, simply because of some of the broad sweeping sanctions that were imposed, not on Russia itself, but on so many of the oligarchs there who control lots of assets and lots of different companies around the world, and really companies that you never would have really even thought of before as being a concern. Or now all of a sudden it comes out that such and such oligarch had a 35% ownership in the company, and his wife had 7.5%, and you're really getting into granularity for counterparties that maybe you didn't before. But when these individuals start getting sanctioned, it changes the conversation, and I think that's why there's been so much focus on it this year. But to give it to you in context, like, sanctions is different than a lot of other areas of the law, simply because it doesn't have to get channeled through the same rule-making process generally. Like, typically, if a government agency makes a rule, there's going to be an opportunity for the affected industry to come forward and to say their piece about why that particular rule is wrong. Not so much here. Both the Constitution itself and the United States Congress have given the president a significant amount of authority to sort of control our relations with other countries. And so over the period of years, based on whether it's been the war in Bosnia, whether it's been situations in Russia, whether it's been circumstances in Zimbabwe, on and on and on, we have sanctions programs now for lots and lots of different countries. And the different sanctions programs have different rules in place. But what's also really key to understand here, as far as the context of all of this, is that because the president is sort of making these rules, and the priorities for OFAC can change on an administration to administration basis. For instance, if you look back at some of the presidential executive orders dealing with Cuba, it's like a ping pong match between 1962 and today, because depending on the prerogatives of the U.S. president, that corridor between the United States can either narrow or it can become much broader. So during the Trump administration, it really narrowed because the prerogatives were different. But now we're seeing all sorts of different opportunities and general licenses and specific licenses from OFAC being granted, and a lot of that, if not all of it, is, again, it's based on the president's prerogatives, and that's unusual in the United States. But it's definitely something that you need to consider, because this stuff is changing all the time. every day I'm getting emails in my inbox from OFAC about this new person being designated or this new general license being created to allow for a certain category of transactions that would otherwise be prohibited. It's daily, and that's sort of the nature of the beast. And so you really need to be on the lookout for it, and to the extent that you have a payments company or you use a service like WorldCheck, things like that, make sure that your entire network is being vetted weekly in an automated way, and your service like WorldCheck will pump you reports. It'll send you reports, and you'll get information in those reports about why there's been a change with such and such. And then you need to look at the reports rather than just freaking out. Look at the report and try to understand why is it that WorldCheck all of a sudden issued a new announcement or gave you a new alert on whatever company it might be. Look at the details. You got to get into those details. So that's sort of the general context. Now, moving sort of one step beneath, the President has all of this authority that he's given by the Constitution itself as well as from Congress in different statutes that Congress has drafted over the years. Now, the President delegates that responsibility for the most part to OFAC. And OFAC is within the United States Treasury Department, and OFAC is the Office of Foreign Assets Control. And OFAC writes the rules, implements the rules, issues enforcement actions, cooperates with the Justice Department, engages in all sorts of market surveillance, receives reports from the affected industries, et cetera, et cetera. And it's a constant job for OFAC to be monitoring all of this, communicating with other agencies, and making sure that the rules are working the right way. Now, when you break into OFAC's regulations, which is part of 31 CFR Chapter 5, Part 500, this is just a short list of the different parts of OFAC's regulations dealing with specific issues. So, you have a whole part of regulations dealing with Cuba, 31 CFR Part 515. 3 different parts dealing with Iran, Syria, Hezbollah, Venezuela, Zimbabwe, Belarus, on and on. They all have their own parts of these regulations. So if you want to understand how OFAC sanctions would apply to any particular country where maybe you do a lot of business, that's where you would go. You would go to the regulations themselves, and you can do other searches. And what's important about these parts of regulations is that they will specify what the prohibitions are, but in many instances they also list what are called general licenses, right? Like categories of transactions that would otherwise be prohibited, but because it's in this part of the regulations, we can engage in this activity. And Cuba is a really good example of having a part of these federal regulations that just has literally dozens of general licenses, right? Like the Cuban government, for the most part, is prohibited. You can't really do business with them in the United States, but you got to really look at the regulations to understand where there might be carve-outs. I'm not going to get into all of that now because we don't have enough time, and we'll keep moving on. Now, this slide has a lot of content on it, and I was instructed not to put too much content on a slide, so let me just sort of walk you through it, okay? When we're talking about countries, right, you got sanctions programs with respect to Iran, with respect to Cuba, with respect to, let's say, Zimbabwe or Ethiopia, right? Just because there are sanctions regulations specifically dealing with those countries doesn't mean that they're all treated the same. Because again, we've got to get into the details of what the regulations say. So, just understanding it from a top level, the jurisdictions that the United States really, for the most part, where the United States requires a hands-off approach, meaning pretty much nothing. Iran, North Korea, Syria, and Crimea, and the 2 areas of the Ukraine. The separatist areas of the Ukraine were designated this year, and those are the LNR and DNR parts of Ukraine. They are now associated with Russia, and in the same way that, or after Russia annexed Crimea back in 2014, those areas are now really hands-off. Now, what that means for those different sectors is that really no transactions with the public sector, no transactions with the private sector. There are general licenses in each of those parts of regulations, including for North Korea, that allow for non-commercial personal remittances, and we need to be aware of that. But to the extent that there's complete government control in those areas, and we would have to use along the lines of a government-owned payor, it really makes those licenses a little bit of a fantasy. So, we can get into the details of how those work, but it can be difficult to comply with, especially if you want to, let's say, make your business on personal remittances to North Korea. That's going to be a lot of work, probably not a lot of reward, and really big questions about whether you'd be able to comply with the regulations as they're laid out. Now, Cuba, Venezuela, Russia, Belarus, and there are many others. Again, these are countries where we don't necessarily have the best relationships with them, and the presidents over a period of time have issued these executive orders telling OFAC to crack down on them, but there's room to work within those jurisdictions, unlike with Iran, Syria, North Korea, Crimea, LNR, and DNR. And so again, if you look at the parts of these regulations, you'll see that there are certainly difficult restrictions that we have to deal with, but for instance, with Venezuela, I can deal with the public sector. I can do business with the public sector in Venezuela. I can send remittances to individuals in Venezuela, but I need to exercise caution because the Venezuelan government is effectively an SDN, meaning a specially designated national. The president of Venezuela is an SDN. And so to the extent that the government is going to have control or an ownership interest in the payor that we're using, or the recipient of the remittance is actually an individual who's acting on behalf of one of these government officials or the government itself, that's something that we really need to know. And so these transactions can be difficult to deal with onesie-twosie when we don't really have systems in place for them, but to the extent that we want to focus on remittances to Venezuela and we have a bank that's willing to work with us here in the United States, that's something that we can put together, although it would take some time and take some work. Again, Cuba, there's general licenses in place that allow us to do some business there. It's difficult. And then we have sort of a third category, Sudan, Ethiopia, Yemen, Nicaragua, where we have entire parts of the OFAC regulations dedicated to them. But really what you start seeing is that there's just a lot of bad guys in those places, specially designated nationals, and we're going to talk about those seconds. These are individuals, all sorts of individuals, that OFAC has designated as being bad guys. You can't do business with them. You can't do business with a company that they own more than 50% either. And so what we see here is that, these SDNs, they can be all sorts of different things. Galeria Page is a shopping mall in Paraguay that's owned by, or at least was founded by, Hezbollah. And so that entire shopping mall is sanctioned, on OFAC's list. PDVSA is the Venezuelan oil company. It's effectively the company that owns and deals with those assets in Venezuela. That's an SDN. I can't do any business with them at all. Tornado Cash. Tornado Cash is a sort of I don't even know what you would call Tornado Cash at this point, but they're effectively I don't know what they are, but what they do is that they have created blockchain addresses where you can send a certain amount of cryptocurrency and it will sort of destroy the record of that transaction and send you back things that you didn't really send them. It'll mix it up. And what OFAC has effectively said about Tornado Cash is that it's assisting in all sorts of bad guy activities around the world. So now, in addition to vessels, in addition to apartments, in addition to shopping malls and people, etc., and presidents, now you've got these blockchain addresses that are sitting on the OFAC SDN list. And so, that's a game changer for sure. And it just sort of shows how what you might not be able to do in the ordinary course if you're part of the government, you can do here because you don't necessarily have the restrictions of like different aspects of federal law when you're the president or when you're acting on behalf of the president. And that's kind of what we have here. And I think it's also important to note that, there's a 50% rule in place. And this sort of goes to what I was talking about earlier with different companies that you may have been engaged with over the years, particularly in Russia, that you may not have really thought about before. But when somebody is sanctioned, when any individual is sanctioned, so too is any other entity in which that person owns at least 50% or controls at least 50% of that company. And so, in addition to, in many cases, wanting to know who your counterparty is as far as the corporation, in certain high-risk jurisdictions, you want to get into those ownership interests as well, similar to what money transmitting regulators do in the United States. I don't just want to know who the company is that I'm dealing with. I want to know who controls it. I want to know who owns it. And again, whether we actually require that of our counterparties that's a decision that we're going to make based on the risk-based program that we've created for ourselves as far as anti-money laundering and sanctions compliance. There's a different category of sanctions that are called secondary sanctions as well. And this might be something that will pop up on a report that you receive from WorldCheck on, let's say I get my reports every Wednesday. This is the kind of thing that you might see in those instances. Secondary sanctions are they're a level lower than your specially designated nationals. And typically, secondary sanctions will apply to non-U.S. persons, non-U.S. companies that are doing business with SDNs and allowing those SDNs to thrive irrespective of the fact that they're SDNs. And so rather than fully sanctioning these secondary parties, what will happen is that the OFAC they'll publish the announcement about such and such becoming a secondary sanction, and then based on the presidential executive order that sort of created that environment in the first place, they'll say, well, this person is subject to Directive 2, 5, and 7 of Executive Order 12345. And so you'll pull up that executive order and you'll see that the person or the company that has these secondary sanctions, it doesn't mean that you can't do business with them, but it typically means that you can't provide them with financing, you can't deal in their debt, and for the most part, transactions with these types of companies need to be arm's length rather than, cases where we're going to be really establishing or perhaps vertically integrating with them in some way. And you see these most often in China and Russia, North Korea, and Syria. A notable example that I included on the slide was Turkey's Defense Procurement Organization. This is really the entity that purchases whatever it might be on behalf of the Turkish military. This occurred because Turkey decided to purchase a Russian an S-400 missile system, which the United States didn't like. And so we slapped these sanctions on the procurement agency for Turkey. I can still, sell products to Turkey, but, to the extent that they needed financing, things along those lines, it would probably be off limits. So plenty of recent enforcement actions to talk about. And they're really recent, and they're pretty relevant to what we're talking about today. And you've got these announcements between September and October of this year, with the first one being Tango Card, that OFAC found engaged in 27,000 different prohibited transactions with folks in Cuba, Iran, Syria, North Korea, and Crimea. And in that announcement, OFAC specifically points out their deficient geolocation identification processes. They also point out in that announcement that the penalty that they had to pay, the $116,000 penalty that they had to pay, was lowered because the company did lots of good things after discovering the violation, including making sure that deficient geolocation identification process was fixed and whatever holes that were perceived were patched up. Same with Bittrex, although this was a much bigger scale, much more money involved, and They recently, in October, had to pay a $24 million penalty for 116,000 violations. And we're going to talk about some guidance that's out there for virtual currency as well. Notice Bank is a Puerto Rican IFE, it's like a hybrid between a bank and a money services business that exists under Puerto Rican law. They had engaged in transactions with Venezuelan SDNs, and as a result of that, it was announced that they had this violation, but there was no penalty because the company had self-disclosed the violations to OFAC, and OFAC really likes when you self-disclose things, which, again, goes towards the anti-money laundering program that you have. You're not going to be able to self-disclose it if you don't know about it, and you're not going to know about it if you don't have a policy and procedure in place to make sure that the relevant people know about it. And so, to the extent you screw up, it's not the end of the world. Make sure that you don't try to bury it by doing stupid things afterward.
Andrew, I'm just going to add one little comment there. When I tell companies, if before you self-disclose, make sure you talk to legal counsel. OFAC will make it sound like, oh, I'm your friend, just tell me everything, send me a letter, and nothing really bad is going to happen to you. And that may be true when they do take things into account in the self-disclosure, and they may reduce your fine or may not charge you, but do not go to the regulator like they are your best friend. Make sure you have someone who is very informed and educated on that topic help you before you communicate that.
Yeah, I think that's a good point. You certainly need to know in advance what OFAC is going to want to see. Don't just go there and say, oh crap, we did this. Let's go in there and say, oh crap, we did this, but here's how we rectified it. Here's how we made things right. And theoretically, you have that done by the time you go in. Theoretically, you can ask OFAC for further guidance of the mitigation that they're going to want to see. And there's a whole appendix. If you look at 31 CFR Appendix A to Part 501, where it really lists these aggravating and mitigating factors that OFAC is going to be looking at when it's determining whether to penalize you $24 million or whether it's going to penalize you with zero. So it's a good sort of regulation or appendix to the regulations to look at to understand sort of what you might be dealing with going into those difficult discussions with OFAC. Bunch of other key concepts. I'm going to sort of brush over these, and I'm going to leave you with some resources you can look at. So these sanctions, they can come up whatever the transaction is that you're dealing with. Maybe you've received a payment from, a supplier, wherever it might be in the world, and the supplier is using one bank, and then there's going to be an intermediary, which is another bank, and then there's going to be your bank here, and so the sanctions can come up in all sorts of different ways. I recently had a Mongolian company that was making a payment to my client here in the United States. My client was a supplier. The Mongolian company was using a Mongolian bank, which was perfectly fine, but the Mongolian bank was using a Russian intermediary bank, and that bank had recently been designated as an SDN. So that payment hits my client's bank here in the United States. My client's bank sits on it, and now we've got to go to OFAC and ask permission for it to be released. And we'll talk about that in just a second as well. Sanctions can have an immediate impact. Again, if you are paying attention, getting emails from OFAC, et cetera, you're going to be getting these announcements daily about new people who have been sanctioned. Theoretically, they owe you money. Well, too bad, so sad. They're an SDN now. Your bank's not going to allow you to receive the payment, even if the payor is willing to send it. So now we've got to go back to OFAC and say, this is what happened. This was the nature of the transaction. There's this $40,000 that's sitting in my bank. I need permission for my bank to release it. And typically OFAC will do that, but sometimes getting them to pay attention to you can take years, literally years, 2-3 years to get a response. So just be prepared for that and make sure that you don't let your counterparties in other jurisdictions, particularly high-risk jurisdictions, get too far in front of you as far as credit management is concerned. Let's keep those balances, at a reasonable level, so that if the worst-case scenario occurs, it's not going to be the end of the day for us. Now, what's also really important in terms of OFAC compliance is record keeping and reporting. And I've listed the specific regulations here that deal with some of those requirements. OFAC expects reports on blocked and unblocked property quickly. They want to have your report within 10 days to the extent that you've blocked something, blocked a payment that might be passing through your system, et cetera. That is on you. And typically, that's focused on financial institutions simply based on, how all of this works. OFAC also has a new requirement for rejected transactions. That's been in place since 2019. Basically, OFAC wants everybody, regardless of what type of business you are, whether you're selling widgets or providing financial services, to the extent that you reject a transaction because it's prohibited under the regulations, OFAC wants a report for that as well. In my experience, I'm not seeing a lot of compliance with that, nor am I seeing a lot of noise from OFAC on that point, but the regulation is there, and I've cited the regulation for it. You can look it up yourself. The reporting with OFAC also does not absolve you of your obligation to file a suspicious activity report to the extent that you engage in you're part of a suspicious activity where the suspicion is triggered by OFAC sanctions. So you very well, for any of these transactions, have two masters, right? You may have your OFAC reporting requirement, and you may have to be dealing with the OFAC regulations, but you may also need to be reporting to FinCEN to the extent that you're a financial institution and you've engaged or you've been sort of privy to this suspicious activity. So keep that in mind as well. And the last point, and I'm going to feed it over to Munir in just a minute, is that we're not the only show in town as far as the United States is concerned. Lots of other jurisdictions in the world have their own sanctions programs. Now in Europe, you've got sort of double the effort because of Brexit. The UK has its own sanctions programs. The EU has its own sanctions program. Australia has a sanctions program. Canada has a sanctions program. And so you sort of really need to understand the jurisdictions that have jurisdiction over you, because to the extent that you're a company and you have, you're sort of subject to all of these different, these different sanction requirements, you need to understand all of them. And that can present multiple opportunities. On the one hand, regulatory arbitrage, right? I can do something over there that I can't do here. And for instance, in the Cuba regulations, it says exactly that I can do things out of a non-US subsidiary that I can't do in the United States. And that's simply sort of the nature of the beast. In other instances, though, it might be different, because especially with respect to Russia, there's lots of companies that are sanctioned by the EU and the UK governments that are not sanctioned in the United States. We, in a lot of ways, in terms of sanctions, have taken a more relaxed approach than the UK and the EU. But now, let's say I'm a US company, but I've got boots in the ground in all these different places. I got to be, creating these policies and procedures as they come up to make sure that, my employees who have EU passports, or maybe they're sitting in my UK subsidiary, they can't do business with so-and-so, even though, the laws in the US say that they can, simply because those people are still subject to the jurisdictions where they're living and where they're operating. And so, there's certainly a lot out there, and sanctions have become pretty popular, as annoying as they are, because they allow us to sort of engage with, enemies, or whatever you want to call them, different jurisdictions where we want to change their behavior in certain ways. And lots of other countries have noticed what we do here and do that for themselves as well. Another important concept is the notion of circumvention, right? If Kim Jong-un wants to buy something from you, it's not going to be Kim Jong-un doing it. It's going to be a third party, and you're going to look at that third party, and you're not going to have any idea that they are working on behalf of the North Korean government. And so this really feeds into our onboarding procedures, things like that. Knowing who the companies are that we're engaged with on the other side, right? And there's FinCEN guidance on this, there's OFAC guidance on this, but basically, put your business hat on. And if you've got a company in Cyprus or in Malta or in a high-risk jurisdiction, and they've got no online presence, they've got no business history, and all of a sudden they're engaging in these large transactions for reasons that are not really explained by the nature of the business itself, chances are they're acting on behalf of a third party, and when that happens, chances are we got to get to the bottom of their corporate ownership structure, right? Who is your boss? Who's controlling you? Who owns you? And to the extent that we can do that due diligence and they provide us with the information that we've asked for in a certain way, theoretically we can proceed. At least we've papered the transaction as opposed to just doing it, right? So there's guidance on that point that you can look up. Some additional key resources that I'm going to leave you with, stuff that I rely on all the time. I guess I'll work from the right side to the left. Number one is the OFAC website. Great website. There's search tools on it. Every list is right there. And to the extent that you don't have access to WorldCheck for whatever reason, you can pull up the OFAC website or just Google OFAC's sanctions search tool. It'll pop right up. You plug in the name. You may get an all clear. You may not. And lots of different policies and FAQs as well, sort of explaining the regulations and the details of them. Now, for payments, earlier this year, or just a couple of months ago, OFAC published a sanctions compliance guidance for instant payment systems. It's a valuable document that you should absolutely review to the extent that you might be impacted by this. We also have a compliance guide for the virtual currency industry. Plug any of these terms into Google or into the OFAC search tool on the website, and those things will pop up. Sort of the main document in all of this in terms of understanding, though, what OFAC wants to see from your compliance program as it relates to international sanctions. We've got a framework for OFAC compliance commitments that's dated May of 2019 and gets into those details in terms of what they want to see from you in order to comply with this, this body of law that they sort of implement on a daily basis. All of those are valuable resources. Here's my information again. That's my contact card, and I'm going to let Munir take it from here. I'm sorry if I ran a little bit long.
So I'll just say I'm thankful to have Munir with us today over from London, so we get a true UK perspective on what they're doing there. And we're also going to look at some of the reports that Andrew mentioned to sort of walk you through an example on what kind of information and how it can sort of sneak up on you, I'll say. So with that, I will turn it over to you, and you're all ready to go.
Good afternoon, everyone. I'm just conscious that there's only a short time between your break leading up to the drinks, and I'm going to be the one that's going to try and keep that as short as possible. I'm sure everyone probably does need a drink after Andrew's intensive session. It's got me worried. But yeah, hi everyone. My name is Munir Khan. I'm the Managing Director of Prolegal Compliance. We're based in London. Our company was established in 2010. We've been working in the industry for 12 years. Our specialty is dealing with international licensing. We also have a consulting division which deals with auditing, risk assessments, and we have an M&A department as well which deals with mergers and acquisitions. Particularly in the last 2 or 3 years, we've seen a lot of companies get affected by the recent events. So it's been an interesting time for companies wanting to buy and sell. In the last 12 years, we've dealt with hundreds of cases where we've helped firms to get licensed. We've helped existing companies to acquire new licenses, help people enter the market in terms of startups. There's a couple of attendees who've got stalls over here, and we've actually been their compliance consultants. Prior to this, I was working for Barclays, and I've done 12 years of experience within the banking and financial sector. So I guess in total, about just under 25 years of working in the industry. I had really long hair when I started, but it's all gone away due to sanctions. Talking about having an effective implementation system in your business for having ways to reduce the risk of getting caught up in all the things that could pop up whilst you're in a trading environment. Dealing with hundreds of cases, you do go through a whole process where sanctions, PEPs, transaction monitoring, plus obviously some other factors for consideration, such as current geopolitics, which obviously affect our industry, and looking at the demand for return back to business post-COVID, because a lot of people have decided that they need to catch up from where they were a few years ago. So there is a bit of hunger, or maybe a desperation, so people want to get back to where they were. So another driving factor. And then, of course, we look at the emerging markets and the risks that are involved in the emerging markets, such as digital, crypto, etc. Andrew mentioned de-risking. That's obviously a popular subject. It's common in the industry. Banks, large payment institutions are very worried about who they're dealing with, and so if they get it wrong, then the banks will get fined. So again, it's a factor for institutions. And then, of course, ultimately, the heightened regulatory requirements. So I guess all of this combined leads us to the customer journey in terms of what have we experienced, our customers have had to go through, and it's very, very similar to everything that Andrew's mentioned in the US. We have a very, very similar program in the UK, and obviously I know we're not part of the EU anymore, but you might as well deem the both of them together, UK, European Union, and the regulators are obviously very mindful of the banks, the financial industry, and even now crypto, because crypto is now becoming more and more popular in the industry. The governments are handing out licenses to certain companies that meet their requirements. So we look at statistics. 52% of compliance leaders said that there is a lack of data and information to properly identify and assess business exposure to third-party risks. 61% of compliance officers expect an increase in investment in their compliance function over the next 2 years. And 90% of compliance officers expect the operating cost of their business to increase due to compliance. And obviously sanctions is one of those things that will help drive those costs up. From a regulator's perspective, I mean, we're sharing, this is by all means not the final checklist. There's a lot more to it. Andrew mentioned ultimate beneficial ownership, source of funds, source of wealth, who is this person, who are you, etc. But regulators do have a certain expectation, and this is also linked to not just regulators, but it's linked to banks, it's linked to anyone that would be helping you service your business. So we start off with, obviously, Andrew mentioned KYB, know your business, know your customers, and then, of course, moving on to managing the commitment internally and externally, having an understanding of the regulatory landscape and knowing that there are sanctions regimes that are out there and they have to be protected and obviously observed. Doing internal risk assessments, that could start off, number one, starts off with your people, and then making sure that you go through the line and look at your customer base in particular and who you're working with, because often you can be affected by someone else's wrongdoing, and we've seen many examples of that over the last few years. Internal controls, and obviously my piece was a little bit more towards dealing with the technical side of sanctions detection, but also how we link it to the human side and what do people in your business actually have to do. This is exactly what the regulators expect to see, this is what the banks expect to see. So having the software systems, the technology, and then obviously the policies and procedures, making sure that you've got experienced compliance personnel, experienced legal professionals to give you counsel, so you make sure that those documentations are actually fit for your business. And from a technology piece, having the appropriate systems to make sure that when you actually run checks, you're actually getting back the accurate results, which can lead you to making sure that you're doing the right decision in terms of whether you're onboarding or not onboarding, and then moving on to whether or not you need to make a disclosure to the FIU or the intelligence departments. Testings and auditing. Obviously, trying to avoid complacency is one of those things that the regulators would like you to see when you have your regulated business, or if you're dealing with a regulated business, and obviously making sure that you do regular audits internally to make sure that your systems are effective and they actually do work. Most importantly, the training aspect. A huge amount of, I think one of the sessions that was before was dealing with agents and remittance companies. I failed to actually put my hand up because I had a comment to make regarding that, but we have MSBs and payment institutions that are reliant on agents as their customers to help them grow their business and do their transactions. One of the number one things that they all fail on is actually training, because I'm not sure how it is over here, but in Europe you'll find that agents often are involved in selling soft drinks and cigarettes, and they just literally get a small fraction of the cost from the remittance transaction, so they're not exactly experts in compliance or financial services. So trying to teach them, look, this is what sanctions is, this is what PEPs are. They're really interested in just getting that $50 commission and kickback. So training is, I mean, you can't miss out the importance of training, especially when it comes to dealing with sanctions. And so this will now move me on to my little case study. So I just wanted to know, is there anyone here who's been thinking about establishing a payment institution overseas or even here? Yeah.
Been discussions, but nothing this year, nothing on the forefront, but just, okay. Revenue, looking to.
Yeah, expand the business. Yep. Yeah. Anyone else? No? Okay. Well, let's look at, for example, a little case study that we looked at, and this is literally going to be the last few minutes, and then you can have a drink afterwards. So if you have your company established, your license issued, you've got your, everything's now set. So it's Nick, isn't it?
Yep.
Nick. So Nick, you'd obviously then go through the very similar process, which is obviously get your customers. Let's start onboarding. Let's start, generate some income. So would a fair portion of your transactions be from individuals, or would they be from businesses?
All B2B.
B2B, okay.
P2B.
P2B, okay, that's fine. So from our research, I mean, obviously the sanctions hits that come out are mainly on businesses, yeah, and like Andrew mentioned in the slide, King Jong-un is not going to buy him, he's going to buy it through a company, like a holding company or a shell company. So risks are more related like PEPs, people of interest, persons of interest, and politically exposed people. But this case study is going to be more focused on, we're trying to keep it in line with sanctions. So we've got here a drinks company, which is established in the United Kingdom, 2018. And they've met with one of your business development managers, for example, and they said, hey, we want to, you deal with Philippines, right? Philippines, okay. So they might turn around and they say to you, we need to buy supplies from Philippines. And so for you, ideal client, drinks, they're obviously bringing in containers, so there's going to be larger remittances rather than P2B. So sounds like an ideal client. And they're also, if you look at the nature of the business, the SIC code is the correct SIC code as well. So it all sounds good. So this type of client goes through an onboarding process with yourself, and obviously regulators would expect you to be able to do the full UBO check and make sure who the parent company is or the individual. So you'd use a suitable software system. This one here is the one that we use, quite popular. They do OFAC, HM Treasury, UN, EU, but there are obviously other providers out there. Because of time limitations, I can't do a piece on what due diligence you have to do on them, but the regulators do expect firms to be able to do an assessment on who you're outsourcing to or using, but we'll save that for another day. So during the onboarding process, you run it through your system and you actually get a hit. Yeah? And on this occasion, it's the sanctions here, we've put it at the bottom. this company has appeared actually on the OFAC list. But yet, they're a British company owned by a British individual, an English lady, and your records would then obviously point out that there's an issue. So it doesn't necessarily have to be OFAC, but it could be HM Treasury, it could be UN, EU. So my closing on this is basically following on from what Andrew's mentioned. He's obviously given you a very rigorous, intense overview. Our journey is more to do with what actually happens on the ground in terms of moving up from starting your business or venturing into new territories. It's hard to address this subject in such a small space of time. Firms have to go through like weeks and months worth of assessment and due diligence before they make a decision to get into this business or work with companies that are already in this business. Because again, you can be linked by association. They do something wrong, it'll come and affect your business as well. And we've got lots of cases that demonstrate that. So I'd like to thank you very much. My company is also one of the European partners for CrossTech. So we help any clients that work with CrossTech and interested in European regulation. So I'll be happy to meet or speak to any of you afterwards. Any final questions? Yes, hi, Miguel.
I mean, you know, it's a few hundred years of history leading to that. I mean, it's just sort of, you got the United States, and then you have the United States that's broken up into 50 different states, and every state has its own regulator. And at the federal level, we've got regulators dealing with pretty much anything you can think of. And in financial services, there's multiple regulators, right? They're sort of, it's like a totem pole of regulators at the federal level when we're dealing with financial services. That's just the way that it's sort of set up here. I don't know, I can't say why, other than that, yeah, sure, consumer protection, that's right. Well, I think I'll also say that a lot of these regulators are created by laws that are drafted by legislators, right? So in order for OFAC to exist or any kind of state banking agency or whatever, there's a law that's passed by the lawmakers saying we're creating that regulator right there. And laws are typically passed after bad things happen, right? We had a number of different federal agencies that were created after 9/11. You're probably going to see more regulators created after, you know, everything that's happening with FTX, et cetera. And the problem is that, you know, these bad things happen, and sometimes these regulatory agencies are created, and even if a certain issue may subside, they're not eliminating the agencies. So over time, as we get 100 years, 200 years, 300 years into, you know, the lifespan of the country, we're just sort of creating all these different agencies. Governments are getting bigger, but that's just sort of the nature of the beast with all of this. It's the result of the circumstances and the way this was drawn up in the beginning. So, I mean, different systems. I mean, we're unique in the sense that we're as big as we are, and that we have the, you know, protections that we do in terms of the Constitution. So, you know, in China, the Chinese government, a centralized government, can regulate just sort of everything, and they don't need to go through all the lawmaking procedures that we do because they can do it by fiat. You know, it doesn't really matter what sort of agencies are involved. But here it's different, and it's more expensive to do it the way that we do it. But that is, again, that's sort of hardwired into the system, at least in the U.S. The EU has tried, right? Like, rather than going to Europe and having to deal with regulators in Italy and France and Germany and all these, there's a centralized authority for regulating a lot of this in the EU, and that's really helpful. And that's great, especially for payments. But, you know, in a lot of ways, that has its own disadvantages. A lot of people in the U.S. have called for a centralized regulator to replace all the state regulators. And irrespective of whether or not it's going to happen, you sort of, you know, be careful what you wish for, right? Because you can create, as we've seen with OFAC in certain circumstances, you can create this big centralized authority that has all the jurisdiction over whatever the subject matter is in the United States, well, what happens when you don't like who's in charge of that agency? And let's say they don't like you or the type of business that you're engaged in. Now you're stuck with just one, as opposed to, at least one of the benefits now is that you can do arbitrage, for regulatory arbitrage. You know, I'm going to set myself up here, set myself up there, depending on what the regulations there are, and make those strategic decisions that way. You can't really do that if there's just one central regulator.
Yes, hi. This is just based upon experience, yeah? We've noticed that the hits that come up are usually dual hits. So the UK HM Treasury will follow the OFAC for a lot of sanction hits. And it's one of those things that the rest of the world is very mindful of, especially in the Western world, for observing and respecting OFAC. That's why you always see OFAC. I mean, here we've got a British company, yeah, regulated England, owned by an English person, but they're observing the OFAC rule. Yeah, so it's a way to try and secure the industry and safeguard the system. Because if, let's say, for example, Nick's company was to onboard this firm and they didn't do the full due diligence on it, then they'd be funding a sanctioned entity, and obviously that's going to be a problem, because then, as Andrew mentioned, we've got the equivalent authorities which will come down like a ton of bricks, and those fines that were pointed previously, they can be quite severe. And also you have to think about what effect that has to the environment. It makes the banks more hesitant to want to open up accounts and service the remittance industry. It makes the organizations like Visa, MasterCard a lot more hesitant to start accepting, like they'll accept payments if you're selling apples and oranges, but the moment you tell them it's a remittance industry, because of the fear factor. So I think the fear is one of those things that protects the industry. We have to be a little bit mindful, and these rules are set there for good reasons, to make sure that the industry as a whole, so it's not just payment institutions, it's everything linked to the payment institution. And so you'll find that even though we're in the, you can be in the UK, you could be in Australia, you can be in Europe, OFAC is often appearing on those 3,500 entities or whatever is currently registered. Some of these systems are updated daily, some of them are updated every week, and you have to make sure that your system provider is able to tap into all the major sanctions list. And obviously Dow Jones, LexisNexis, even Comply Advantage out there, they're well known for making sure that the data is actually accurate. I think we're going to be wrapping up for now, unless there's any other questions. But I think this has been a great session. Kathy's mentioned something very important, which also is about being careful when you need to make that report, and you make sure that you need to get accurate legal counsel. Because if you accidentally have done something wrong and blurt it out, if you're not prepared for that journey of what happens when you report to we call it the FIU, Financial Intelligence Unit, but when you actually report it, you have to be ready for being prepared for that journey. Thank you very much for attending. Enjoy the rest of your evening. Thank you.